Hello, I'm Ed, the business rescue expert, and I'm going to answer some of your questions about winding up petitions. So, what is a winding up petition? A winding up petition is one of the most serious legal actions that can be taken against a business for non-repayment of debt. It's the final stage of a process that will have seen various communications, including requests for payment and a statutory demand. If payment remains outstanding, then a winding up petition may be filed in court and served on the company. What happens if you ignore a winding up petition? Once a petition is filed, you'll be informed of a date for a court hearing. The date for which is usually between 3 to 10 weeks after you find out about the petition. At least 7 days prior to the hearing, if you have ignored it, then the petition will be advertised in the London Gazette. Once the advert is placed, the company's banks will freeze all of its accounts and prevent any payments from being made out. Directors need to be aware that during the period of the petition being issued and the court hearing, any payments the company makes can be invalidated if the company is subsequently wound up by the court. Finally, at the hearing, the court is likely to make a winding up order, placing it into liquidation and forcing it to close. This is likely to lead to investigations into the director's actions, especially in the months leading up to liquidation. What are my company's options? Things will begin to move quickly, so you have to act fast. You can request an adjournment of the winding up petition. The court will normally allow at least one adjournment to give you more time to either negotiate or put in place some of the following options. You can come to an informal agreement with a petitioning creditor. Be aware, though, that the winding up process will have cost in the region of £1,450 to £5,500 to initiate. In most cases, a creditor will expect full payment quickly and for you to pay their costs on top. This means that payment terms can sometimes be difficult to agree. You can work with an insolvency practice like Business Rescue Expert and apply for a moratorium. This gives the company legal protection from the winding up petition for a 20 business day period, enabling it to formulate an exit strategy, such as realizing an asset to repay the debt, or to move into another restructuring process, such as proposing a company voluntary arrangement. See our CVA animation for details of how this works. In short, if the company has other debts other than the winding up petition, it may be a good idea to tie them all into one contractual and affordable repayment process called a CVA, or you can initiate a voluntary liquidation yourself. See our liquidation animation for more information on how this works. If you know you need to close your business, you may find it easier and cleaner to appoint an insolvency practitioner yourself to place the company into voluntary liquidation. This way you'll get proper advice on how to legally manage the shutdown, rather than the court forcing the closure. Need help with a winding up petition? Contact us at Business Rescue Expert to find out more about winding up petitions and how to deal with them effectively and efficiently. Let the Business Rescue Experts help you help yourself.